On the afternoon of July 24th, 2024, what began as a routine father-daughter outing in Sonoma County, California, descended into a traumatic high-risk felony stop and a catastrophic medical emergency. 45-year-old Jeffrey Callahan, a type 1 diabetic, had spent the day shopping with his 6-year-old daughter, stopping at McDonald's before heading toward a local park. Unbeknownst to Callahan, his continuous glucose monitor had failed, preventing him from receiving critical alerts that his blood sugar levels were rapidly plunging into severe hypoglycemia. As Callahan lost consciousness behind the wheel, his vehicle swerved, prompting a 911 call reporting an erratic driver. When Officer Forrest Whitehall of the Sebastopol Police Department initiated a pursuit, Callahan crashed into a ditch. What followed, captured on police body-worn camera, was not a routine arrest of an intoxicated driver, but the forcible subduing of an incapacitated man in the midst of a life-threatening medical crisis. The central constitutional question now before a federal court is not merely whether force was used, but whether that force was objectively reasonable under the Fourth Amendment when applied to a nonviolent citizen experiencing a profound physiological breakdown.
Lincoln 5 continuing southbound, almost striking vehicles on oncoming traffic between the center median and the bike lane. Speeds are 37, moderate traffic. Can you advise the SO?
They're online now.
40.
Copy, over TC 2400, go.
Lincoln 5 TC, across from Antique Society, start code 3 medics.
Copy.
Police! Turn the truck off! Turn the truck off! Lincoln 5, high risk stop. The exact numerics are going to be 2580 Graph South. The car. Step out of the car right now. Step out. Step out. Look at me. Step out. Step out. Go down to your stomach. Down to your stomach right now. Down to your stomach. Down to your stomach. Go down to your stomach right now or I will tase you. Go down to your stomach right now. Lincoln 5, taser deployed. Stay on the ground. Stay down. Stay down. Get on your stomach. Roll over on your stomach right now.
Under Fourth Amendment jurisprudence, police officers are required to evaluate the necessity of force based on the totality of the circumstances known at the moment. In the landmark Ninth Circuit case, Bryan versus McPherson, 608 F. 3rd, 614, the court firmly established that a taser deployed in dart mode represents an intermediate significant quantum of force, a painful and debilitating intrusion that must be justified by a compelling governmental interest. When assessing the governmental interest under Graham versus Connor, courts evaluate three core factors: the severity of the alleged crime, whether the suspect poses an immediate threat to safety, and whether the suspect is actively resisting or attempting to flee. Here, a court examining Officer Whitehall's split-second decision would analyze whether Callahan's slow movement was active resistance or physical incapacitation. While officers initially responded to a report of erratic driving, a potential public safety hazard, the driver was stationary post-crash, visibly disoriented and half-naked or minimally responsive, as established in Ninth Circuit authority like Diorle versus Rutherford. When officers confront an individual who is distraught, disoriented, or suffering from an apparent physical or mental health crisis, the government's interest in deploying significant force is substantially diminished compared to apprehending an armed or violent suspect.
Roll over! Get on your stomach! I I will keep tasing you. Stay on your stomach. Do not move. Arm out. Arm out. Anything to drink today at all?
No.
Okay.
I don't drink.
You don't drink at all?
No, sir.
Okay.
I do jiu-jitsu. I train over at Terrell's. I got a brown belt.
Would you be all right to doing a preliminary alcohol breath test later on today?
Anytime.
Okay.
Right now, anytime.
How do you feel right now?
I feel better now that she gave me some sugar. I
Okay.
feel my brain's working. But when you first put me in the car, I didn't know what. I had no clue what was going on.
Gotcha. Okay.
Yeah, man.
All right. Your first name's Jeff, right?
Yes, sir.
All right. Jeff, hang tight. I'll roll this window down, so if you need anybody, just holler. All right.
Thank you.
What's that, Jeff?
Baby, the most important thing to me is my daughter.
Your daughter?
She's okay.
That was your daughter in the car?
That's my baby.
Okay.
That's my.
I think she's okay. All right. I think she's okay. She went to the hospital in an ambulance, but from everything I saw, I think she's going to be okay.
The evidentiary landscape shifts dramatically the moment law enforcement becomes aware that a suspect's conduct was driven by a severe medical event rather than criminal intent. According to the federal civil rights complaint subsequently filed on Callahan's behalf, Officer Whitehall broke Callahan's arm and bloodied his face during the prone restraint. However, the critical legal exposure for the department expands beyond the initial physical force to the subsequent decision-making once medical personnel verified Callahan's hypoglycemia. Under California law and Fourth Amendment standards, probable cause must exist for every stage of a detention and arrest. When objective medical evidence, such as blood glucose testing, confirms that an individual's erratic driving and non-responsiveness were the direct result of a type 1 diabetic emergency, the legal justification for operating under a driving under the influence theory rapidly evaporates. According to Callahan's lawsuit, officers were placed on direct notice that his continuous glucose monitor had ceased functioning. A core issue raised in the civil filings is whether officers engaged in a post hoc effort to formulate charges, including felony child endangerment and vehicular evading, to insulate the department from civil liability regarding the force deployed in front of Callahan's young child.
So what are we at? Where are we at here over here?
I don't think this is a deuce.
I think it's a diabetic issue.
I think it's a diabetic.
Yeah. From what I talked to Mom,
Okay.
she said he's type 1 diabetic, and there is a court-ordered custody arrangement. He's not supposed to have her right now.
He has the little blood thing on his arm or whatever. He said it wasn't operating correctly.
The car.
So I'll let him know that his blood sugar was tanking. He said he never saw my light. He said he never heard my siren.
That's all consistent with diabetes.
It is, yeah. So at this point, I don't.
It's
He's got all the signs, like the objective signs, but all that can just be diabetic as well.
explore the child custody thing.
Yeah.
Find out, run a 26 on him, and then I'll provide her the mom's information and see if if we can find that court order.
Okay.
And see if it says that he's not supposed to have it. There's a arrest for that.
Yeah.
But the thing is, we're going to have to sit with him. Now, nobody has told him he's under arrest yet. Has he been Mirandized?
He's been Mirandized, and you're to answer my question.
Okay. Did you ask him any of the FST stuff?
Yeah, so be advised, the review is coming a little early, so be mild.
Hey, ladies, do you know who this is? The man with the...
The only thing was asked if he had anything to drink today, and he said no.
Yeah.
That's the only FST question.
So, are you hearing what? Nope. This guy is behind metal. Yeah, I know. I heard. It's down to it's probably not a deuce. It's probably a diabetic issue. Let's see. He's saying that he didn't see lights. He didn't know we were trying to stop him. He thought there was something wrong with the car. So we'll do the whole FST investigation thing. Get blood taken. I talked to Mom. She said he's type 1 diabetic. When I told her he was in a crash, she said, "Oh no, he's a diabetic." And he might have,
yeah, and it could very well be. I heard the number.
Yeah.
You guys told me the number. I heard the gal. Yeah. So it absolutely.
The other thing is he's not supposed to have a daughter right now. There's a court-ordered child custody arrangement, and he's violated that.
So, and the other thing is, diabetic fits like that.
Yeah.
Every one I've been in, they're short-lived before the blackout.
They're not. You said he was unresponsive when you pulled him over.
Yeah.
You weren't getting anything from
So that could have happened, but the
In civil rights litigation brought under 42 U.S.C. Section 1983, government officials often invoke the doctrine of qualified immunity, which shields officers from personal liability unless their conduct violated clearly established constitutional rights. However, recorded admissions by officers, contemporaneously acknowledging that a suspect was experiencing a medical emergency rather than committing a crime, create formidable hurdles for a qualified immunity defense. When officers state on body camera that an arrestee's symptoms are all consistent with a diabetic issue, yet proceed to pursue felony charges such as vehicular evading or child endangerment, a jury may infer malice or an improper motive. Under Supreme Court doctrine in Saucier versus Katz and Pearson versus Callahan, courts must evaluate whether a reasonable officer possessing the knowledge that the suspect was medically incapacitated could have believed that continuing to book him on violent felony charges was lawful. Furthermore, as noted in civil rights filings, when prosecutors from the Sonoma County District Attorney's Office ultimately reviewed the case file, they formally declined to file charges against Callahan, a pivotal factor that significantly strengthens Callahan's claims of judicial deception and retaliatory prosecution.
travel from downtown to here at the highest rate of about 30 miles an hour, most of it between 20 and 30. That's an awful long time because the diabetic episode can be induced because of the alcohol you ingested.
So you did the Miranda thing. Find out about the. Is he coherent?
Oh yeah.
You're able to talk to him.
And the dad in me hopes it's diabetic.
Yeah.
Seriously. I don't want to think about that poor, beautiful little girl having to live with that. So, start working. So is mom on her way?
She's headed to the hospital.
Okay, good. So if that gets extended at all, just get a hold of Sarge at Sonoma County just to let him know what's up.
Yeah. He was aware. I gave him the phone number for the mom so that his deputy can.
Oh, good. Oh, okay. Oh, you got a hold of him before he
There's
took
a
off.
deputy over there waiting with the daughter.
Yes. No, I know that.
The sergeant. Yes.
That's what I
talked
said.
with their sergeant.
So you got Sarge, you got that?
Yeah.
Okay, good.
So work the DUI,
work the deuce.
foul engagement, and the pursuit and all that aspect. But see if we can do FSTs with them.
Okay.
They're going to probably want to take him to the hospital.
No, they released him
Okay,
to us.
releasing him?
Yeah,
Okay.
but I figured we were going to take him anyways.
He won't be able to go to jail. He's medically cleared.
Yeah.
So if it goes that route, we're taking him to jail. Then it's going to be he'll go to the hospital anyway.
Following the incident, public records and court filings confirm significant legal developments. On February 10th, 2025, the Sonoma County District Attorney's Office formally refused to prosecute Jeffrey Callahan on any of the recommended felony charges, citing a lack of evidence of criminal intent. On July 24th, 2025, exactly 1 year after the incident, Jeffrey Callahan filed a federal civil rights lawsuit in the U.S. District Court for the Northern District of California. The complaint names Officer Forrest Whitehall, Officer Cameron Fensky, Officer James Hickey, and the City of Sebastopol as co-defendants, alleging excessive force, false arrest, and intentional infliction of emotional distress. In an official response provided to McClatchy News, Sebastopol Interim City Manager Mary C. Gorley stated that while the city generally does not comment on pending litigation, it looks forward to defending its officers in court and responding to all allegations through the legal process. Public employment records indicate that Officer Forrest Whitehall subsequently departed the Sebastopol Police Department and joined the Petaluma Police Department. As of the time of this recording, the federal civil lawsuit remains pending in district court. Evaluating this entire interaction through the lens of constitutional standards, police procedure, and tactical de-escalation, here is our final performance breakdown. For the officers involved, grade D-. While officers initially faced an erratic driving report, their rapid escalation to intermediate force, tasing an incapacitated, shirtless, and non-threatening man, shows a severe lack of restraint. More critically, Once medical personnel confirmed a type 1 diabetic emergency, continuing to construct felony charges raises serious procedural and constitutional concerns. For the citizen, Jeffrey Callahan, grade A minus. Callahan was fully cooperative to the physical extent possible during a life-threatening hypoglycemic breakdown. Once glucose was administered and his cognitive function returned, he remained remarkably calm, answered all questions transparently, and immediately consented to blood and breath tests. Where do you draw the line between an officer's split-second assessment and a failure to recognize a medical emergency? Should officers face personal liability when body cam evidence shows they recognized a medical condition mid-investigation? Leave your thoughts in the comments below. If you found this constitutional breakdown informative, subscribe to the channel and turn on notifications for more in-depth legal analysis and body cam breakdowns. Thank you for watching.